May it please the court,
Yes, sir.
Mr. McCallum, Mr. Cole, ladies and gentlemen. We've seen a lot of evidence. We're on our fourth week of trial. The state has flooded you with evidence pointing to my client, Mr. Borum, as the person who is guilty of killing Justin Carr. Now the decision is yours. We are talking about the rest of that man's life. The judge is going to instruct you, no parole, no rehabilitation, no anything. A cell with four walls, life, forever, that's it. I find it interesting, and I'll go back in just a moment, but I find it interesting that Mr. McCallum just told you all not to consider anything with respect to second-degree murder. I'm going to tell you a little bit about what the judge is going to instruct on second-degree murder, and I'm going to ask you to consider that, of course, because otherwise, why would we give that to you as an option? I find it interesting that Mr. McCallum said don't consider that, because it's the same way throughout this case, throughout all of this evidence, throughout the 2 years that this case has been happening, being investigated, how CMPD, the lead detective in this case, Detective Pack, chose not to consider things also. It's very interesting that the state and CMPD are both choosing not to consider very important things in a case of this magnitude. First, when Detective Pack testified, I believe it was on Friday of last week, he talked about what happens at a crime scene and what his role is at the crime scene. And he's the lead detective, so there are other people who work under him who are gathering evidence and things of that nature. And Detective Pack told you all that his investigators found this one shell casing, 9mm shell casing, WIN, I believe somebody said that stood for Winchester. Detectives Pack and Jones told you all that typically we don't get fingerprint evidence or residue off of something like that because of the heat that's created. It's tough to get. Notice that neither one of them said it was impossible. But still, they decided not to try. And when the district attorney asked Detective Pack, well, it was found after the scene was contaminated for 4 or 5 hours, there was a lot going on, anything could have happened. People could have been bleeding on it, sweating on it, touching it, moving it. Detective Pack said it would be irresponsible to test that shell casing because that might lead them to the wrong person. Might also lead them to the right person. Is it really more irresponsible to test something at risk of getting the wrong person than it is to test something to make sure you've got the right guy? Do you remember when Detective Jones testified about those people he saw in this video when he says he saw my client shooting? And he said, well, yeah, there were 3 other people in white shirts, black males around right where your client was. I asked Detective Jones, okay, who were those people? I think we talked to one of them, but I can't remember. It's not who he was looking for. It's not what he was looking for. It didn't fit their theory of the case. And let's remember why we were all here in the first place back on September 21st, 2016. It's because on September 20th of 2016, CMPD shot a man without a gun. The protest evolved because of that issue. And so best believe that CMPD had to get this done quick, fast, and in a hurry. And when you do something quick, fast, and in a hurry, you leave out important evidence like, did Mr. Borum ever touch this shell casing? All those other the bullets that were found all over Mr. Borum's house. Did anybody come up here and tell you how many people lived at that house? Who had a pistol permit, a concealed carry permit? Who bought the rifles that were there? Whose ammunition it was? And the ammunition that was at that house, boxes of it, hadn't been fired out of a gun. They were whole. How long would it have taken? You heard Mr. Cole ask the question. We've got a crime lab right here in Charlotte. And in fact, other counties come to us for our crime lab because we're fortunate here. How long would it have taken to take just one of those full bullets that hadn't been fired at all to find out if this man ever touched it? Just one. They didn't do it because they didn't want the answer. They didn't do it because they want you to think This is the only possibility. This is it. Now, Mr. McCallum did a good job of explaining the law to you all, and I'm not going to bore you with explaining the elements and details again, but I also find it interesting that the state's asking you to convict my client of first-degree murder and send him away for the rest of his life based on two different theories. Maybe they don't think either one of them is particularly strong. They throw in this rioting thing, and I want to start there. Felony murder can be called first-degree murder also, and send my client away for the rest of his life. And they say that if he was engaged in the riot because other people were breaking glass and throwing pots at the police and all these things they were doing, that he can be convicted of felony murder if someone died. Well, if that's the case, you remember all the testimony. Ryan James, Kenny Bowden, officers, everybody testified that things were pretty peaceful. It was loud, but things were pretty peaceful until the police officers started walking through the crowd from the epicenter to the Omni, and until the police officers barricaded themselves in front of the Omni. Not to protect people, to protect property, to protect the Omni Hotel. And at some point, I believe it was Officer or Detective Amos who said he was on the CEU team, and they pushed people back with their batons and then retreated again because they were getting overrun. Was Mr. Borum overrunning the police? Was Mr. Borum breaking the Omni glass? Was Mr. Borum throwing things at the police? No, he wasn't. And so the state is trying, because there was an assembly of more than 3 people, hundreds, to say that Mr. Borum should be found guilty of felony murder because other people were rioting. And sure, he was there. You can't dispute that. He said he was there. He told you what went on when he was there. The state says that Kenny Bowden also told you what went on when Mr. Borum was there. They kind of tried to brush over Mr. Bowden's convictions, but they're important. And the judge is going to instruct you that those convictions specifically, you're allowed to consider those type of convictions in their bearing on his character for being truthful. And you notice when he got up on the stand and put his hand on that Bible and swore to tell you the truth, head straight down. Yep, I do. Not making eye contact with any of you. Not making eye contact with the DA or the clerk. Yep, I do. On July 1st, 2015, Mr. Bowden was getting convicted of committing fraud. 3 counts of identity theft, 1 count of forgery. That wasn't enough. September 21st happened. And Mr. Bowden, on October 17th of 2017, got convicted of higher level fraud. And when I asked him about it, he tried to get cute and dance around, and he said, well, it's not as bad because if you're taking someone's identity, they always get back. You can't really steal someone's identity. This was bank fraud, so I'm not defrauding an individual person, I'm defrauding a bank. But what is he doing on probation in Georgia for fraud? Committing more fraud, committing more lies for his own personal gain. And don't for a second think that he's not good enough to fool everybody in this room, because he is. What do I mean by that? You remember when I asked Mr. Bowden specifically about when he was saying he saw Mr. Borum shoot Justin Carr? And I got up and demonstrated what Mr. Bowden was doing. Excuse me for turning my back to you all. Mr. Bowden said he had seen Rodney, guy in the blue shirt, go down, right? And if Rodney was on the ground, then Mr. Carr was also on the ground at that point because they fell at the same time. Go back and watch the video as many times as you want to. There might be a split-second difference. Rodney was on the ground at the same time as Mr. Carr. I don't know what happened to Rodney. The state didn't tell you what happened to Rodney. Mr. Ali said, yeah, I saw him looking around. He was on the ground, but he was looking around, so I moved on to Mr. Carr. Like any person might do. What knocked him down? Did he trip? Was it the tear gas that was coming out? Was he being pelted with pepper balls? Was he being shot at? I don't know. But neither do they, and they didn't tell you about what happened to that person that fell down at the same time. Now, back to Mr. Bowden. Rodney's on the ground, which means Justin Carr's on the ground. And Mr. Bowden said he was running this way and looking back down at the ground to his right because Rodney was down, waiting for him to catch up. And at the same time, mind you, Mr. Carr should already be on the ground if you're looking at that video. He says he also saw my client with his right hand throwing a gun back this way, aimlessly shooting. When he testified about what my client was wearing. Remember that the state asked Mr. Bowden, did you watch anything to prepare for your testimony? And he said, yeah, I'll show you the video. I watched my interview, I watched the video to prepare for my testimony with you. Even still, after he saw this video, where he ostensibly identified my client as wearing a white shirt, still told you that that night my client was wearing a black short sleeve shirt. Why? Because back on October 31st of 2017, that Halloween, when he talked to the police, that's what he told them. And so he had to make sure his story matched that, because he knows he's got fraud convictions, and he knows if his story doesn't match what he said before, he was going to get torn up about it. He's smart. He knows how to work everywhere. That's his job. Now, it's a difficult person to address because, on the one hand, that's the state's way of proving premeditation, deliberation, and malice for first-degree murder. That is the only person who can testify to anything related to Mr. Borum's purported intent. The only person. And they know that. And that's why they told you, don't worry about those convictions. They are what they are. And that's why, I'm sure, they had a tough time deciding whether they were going to call this guy to the stand at all. Because they need him to prove first-degree murder. But they know he's a liar. And they still put him in front of you and let him put his hand on the Bible and say he was telling you the truth, but he wasn't. And they told you that most of that stuff corroborated itself. He was there at the candy bar, and he was there when he was screaming, grab a block, shoot back. Listen to those videos again. You've heard Mr. Borum talking now for hours, phone calls, interrogation. Does that, whoever's screaming, sound like Mr. Borum at all? Kind of sounds more like me than Mr. Borum. Go back and listen and see if that sounds like my client from what you've heard. Screaming, grab a block, shoot back. There were hundreds of people out there. I don't know who was chanting. I don't know what everyone was chanting, but people were chanting. People were angry. People were upset. And Mr. Bowden saw this as an opportunity. And I want you to pay attention to the timeline. July 2015, fraud convictions. September 21st, 2016, protest happened. October 17th, 2017, fraud convictions. 2 weeks later, lo and behold, now he's in federal custody. And Mr. Cole asked multiple times, do you have any deal with the state? No. Do you have any deal with the federal government? No. No deal. No deal. When I asked, no deal, but anything's possible. And that's what Mr. Cole told you in jury selection, right? He hopes to get a deal based on his testimony. And I guess they didn't prepare that part too well because Mr. Bowden was rehearsed, no deal, no deal. Mr. Bowden knows if this goes well and the state gets a first-degree murder conviction, he might be out of prison a little bit faster and get back to defrauding everyone again. What was he doing in September of 2016, in October of 2016, in November of 2016, and all the way up until Halloween of the next year, 13 months later? What was he doing? Why did he come forward then, before he was in custody? Didn't suit him until he was in prison. Didn't suit him until there was no way out. Didn't suit him until he stood to gain from it. And what did he call it? Conscience got the best of me. Maybe when he put his hand on that Bible, his conscience got the best of it. Maybe. But he still sat in front of all of you and told you, yeah, he was wearing a black shirt, even though he's now seen the video of my client wearing a white shirt. Because he's got to make sure you believe him. He's got to make sure there are no holes in his story, or there will be no deal. So, we talk about intent. The state talked about transferred intent a lot. And the judge is going to give you the instruction, and what that instruction says. And Mr. Cole and Mr. McCallum demonstrated pretty well in jury selection. If I intend to shoot Detective Pack, but I instead hit Mr. McCallum, that's transferred intent. Mr. McCallum steps in the shoes of Detective Pack. What police officer was Mr. Borum trying to shoot? If you look at the CNN video that they've played multiple times, what you see is the police officers pushing people away, retreating, and they're way back here under an overhang. And if you go back and watch that video, what you see, if this is the Omni, there's a concrete wall separating Mr. Borum from any police officers because they're 10 feet back here. Police officers are out here dealing with protesters, talking to people. They were overrun at this point. The police are back here. And so how in the world, if you believe Mr. Borum was shooting at all, how in the world could he have intended to kill a police officer if there was a concrete barrier between him and all the police officers? You see on the video, hand goes up like this. See Mr. Borum turn around this direction. So the police are back here. More specifically, the transfer intent doctrine states if the suspect intended to shoot or harm one person, that is imputed onto another person. Again, their example. Detective Pack imputed to Mr. McCown. The state's sitting here telling you, well, he was shooting at the police. Well, there were 20, 30 police officers out there, hundreds of civilians. Which police officer was he shooting at? If they're so sure he meant to shoot a police officer, if they're so sure that he meant to kill a cop, because on all his jail calls and all his interrogation, he's saying, oh, I did it, and they got me doing it, and they saw me doing it. Pay attention. They're asking not to pay attention to certain things, or rather, Mr. McCollum said, I'm going to ask you not to pay attention. Did Mr. Borum ever say in any of those jail calls where he's being so honest to all of his friends, even though he's being recorded, and in that interrogation where he's getting hounded by these detectives over and over again, even after he asks for a lawyer, even after he says, I need a lawyer, continue to ask him to talk to him? Does he ever say, I'm shooting at the police? No. The officers lied to him, and they told you they lied to him, because we were just trying to get him talking, and so we're allowed to lie, that's fine. Apparently Mr. Bowden's allowed to lie, that's fine too. Detective Pack and Detective Jones came into that interview room with one goal in mind. That one goal was to find out that Mr. Borum was shooting at police officers. And why did they have that one goal in mind at that time? Do you remember that little bit of questioning I did with Detective Jones when I asked him, did you see any text messages? Did you receive any text messages from your team? Yeah. And one of those asked specifically, was he shooting at police? Yeah. Well, what other evidence did they have at any point that Mr. Borum was shooting at police until Kendall Bowden showed up 13 months later? What talk was there of shooting at police other than that text message? What evidence was there until this fraud, this trickster, this guy who lies, said he was shooting at the cops? None. Go back through all the evidence, through everything. And the state argued that, well, you know, you can see the angle, you can see where he's pointing. Remember that concrete wall. Remember that Mr. Bowden testified, Mr. Borum shot like this blindly. Remember how Mr. James testified that he saw a guy with a gun in his right hand. Remember how Detective Jones said, I see your left hand and you were holding it with your left hand. It seems that the state's witnesses don't even know what happened, because they're telling different versions of the story. It seems like Detective Pack and Detective Jones, lying or not, think that Mr. Borum was just shooting to clear the crowd. Or maybe they were just feeding him that story because they needed a conviction, because they needed this to get the focus off of CMPD, because their focus was yesterday. They had to wrap this up. They had to make sure they got someone. And they found my client. Now, the judge is going to instruct you on some elements of second-degree murder, and I want to just read those to you briefly. The judge will give you a copy of all these so you don't have to write them down. But there are going to be 3 different choices with respect to second-degree murder. 1, if you find the defendant is guilty of second-degree murder, you must unanimously find 1 or more of A, B, or C below. 1, is it malice, meaning hatred, ill will, or spite? I don't know who the state has proved that Mr. Borum had malice or ill will toward. Certainly not Justin Carr, certainly not any police officer, because it doesn't sound like he ever talks to any police officer. Is it malice? Number 2, is it malice defined as a condition of mind which prompts a person to take the life of another intentionally or to intentionally inflict serious bodily harm which proximately results in another's death without cause, excuse, or justification? Or 3, is it malice that arises when an act which is inherently dangerous to human life is intentionally done so recklessly and wantonly as to manifest in mind utterly without regard for human life in social duty and deliberately bent on mischief. I would argue to you, ladies and gentlemen, that if anything, the state may have proved that last second-degree murder count. They spent a long time showing you what happened at the candy bar, talking about considering the chain of events that went on. What happened with Mr. Borum said he threw a rock, but they said it was a gun, and then he said they got me in the shot with the gun. It sounds like someone, if anything, who's deliberately been on mischief. It sounds like the state spent a lot of time, almost 4 weeks, proving that someone was deliberately bent on mischief. Mr. McCallum said it. He wasn't there to protest. He wasn't there to be heard. At least that's not what the state thinks. He was there to cause trouble. But was he there to kill a police officer? And what police officer was he there to kill? I have no idea. The state hasn't presented any evidence of that. Now, what's also interesting is this gun box that the state has presented to you. Empty gun box, all of the components that you might find in a gun box. But when asked, well, did the state ever tell you what kind of gun this was? Depending on what you believe, it's 40, it's 45, it's a 9mm if you believe, it's a shell casing. I have no idea what kind of gun was possessed. And you saw Detective Pack and Detective Jones hound my client saying, where was the gun? Where was the gun? And ultimately said, well, I threw it over Independence somewhere. Did they look for it? Nope, that would have been too hard. Just like testing that shell casing would have been irresponsible. Just like when they found that fragment in Mr. Carr's head. Dr. Lozano told you it would not have any medical value. Well, if you knew it was a metal fragment, a piece of metal of some sort, do you think maybe you could have compared it to that and seen if it was a bullet or some piece of one of these grenades that no one collected or anything other than this exact shell casing that was found? Did Dr. Lozano tell you what size bullet hit Mr. Carr? He talked about measurements. Did he tell you what kind of bullet hit Mr. Carr? Because we've got 9, 45, 357, all kinds of different possibilities. But the state didn't follow up to prove to you, beyond a reasonable doubt, what killed Justin Carr. And I think Dr. Lozano's last piece of testimony is very telling. Ms. Harris asked him, what is beyond a degree of medical certainty? A reasonable degree of medical certainty. What is that? I usually start around 50-51%. This is not a 50-51% case. That's not good enough. You know what might have helped? Him pulling that fragment out to see what it was. You know what might have helped? The state hiring a ballistics expert, because Detective Jones and all the other officers testified that they weren't that. Hiring a ballistics expert whose job it is to assess trajectory and angles of bullets to see how and when they were fired and if they struck what you said they struck. Too hard. All the resources the state of North Carolina has, and they couldn't look for a fingerprint. Mr. McCallum addressed briefly possession of firearm by felon. I'm going to address that briefly as well. I think you've heard enough about that. If you believe that there's a firearm, Mr. Borum was in possession of a firearm at any time, consider that evidence as you will. But when we're talking about first-degree murder, and we're talking about the rest of the man's life, the state did not bring its A game. The state brought 50 to 51%. I think one of our jurors said it best during our jury selection process. It's kind of like a puzzle. And when you take one of these cases, this kind of magnitude, this importance, you don't know what you're going to get. You meet your client, you talk, you don't know what's coming next. It's kind of like a puzzle. All the pieces hopefully fit together in some way, and both sides work accordingly. But what the state has done is given you this piece of the puzzle, the pieces that they think are important. And if they think that this quadrant of the puzzle is the whole puzzle, they ask you not to consider everything else, like Mr. McCallum just told you. Don't even consider second-degree murder. Don't consider the arguments that the defense counsel is going to make. Don't consider any of that because we didn't tell you anything about that. We don't have any evidence to back our statements up with respect to that stuff. So don't think about it. And so it's your job to decide what evidence to assess. It's your job to decide what evidence to ask the state for. And if you find yourself wondering, why didn't I get this? Why didn't I see this? Why didn't the state try harder? Why didn't they go a little further? I would argue to you, ladies and gentlemen, that that's reasonable doubt. It's kind of like a chain. If you miss one piece, one link has fallen out, you can't wear that chain. The state found Rayquan Borum. They found Rayquan Borum and they didn't look any further. You remember when the detectives were talking about Callie, and Mr. Borum on the calls was talking about Callie being with him this whole time, and Callie was right next to him when this alleged shooting happened? And one of the DAs asked Detective Pack, well, did you ever talk to Callie? Yeah. Was it willful? No. We had to arrest him. Where is Callie? Where's his interview? If he's the guy that knows Mr. Borum the best, and apparently Mr. Borum met, he's the guy who's kind of the linchpin in all this. He connected Kenny and Mr. Borum. He interviewed with the police under arrest about this incident. Why don't they want you to know what he has to say? The state has made a big deal about Mr. Borum's jail calls, and there's nothing that I, or Ms. Harris, or Mr. Borum can do to take back things that are said on those calls. But if you listen closely, what you hear is what they said. Mr. Borum sat for almost an hour, maybe more, head down. Well, at first they were talking, and when he realized they were accusing him of murder, he got really quiet. He got really quiet because, wait a minute, murder? Huh? And after a while, Detective Pack and Detective Jones got bored. Excuse me, not bored, frustrated. And what did they do? They decided they were going to give him a story to open him up, to let him talk a little bit more. Tell him what happened. And so do you remember, after my client asked for an attorney, and Detective Pack told him, remember that this is your chance to tell your, write your narrative, tell your story, tell what happened. When, at any point, in any of this stuff, did my client tell a story that wasn't given to him by the police? They showed me a picture of him, I mean, up in it, bruh, that first CNN video when Mr. Bowden said he was up in a gun. They told me I killed somebody. They told me I was shooting the crowd. They told me I was trying to clear the crowd out. Whatever they told him, they kept trying different angles. They didn't care what he said. All they wanted him to say was, I had a gun and I shot a gun. They can handle the rest. We can handle the rest of the story from here. So it wasn't really his chance to tell his story and tell his narrative. It was their chance to get somebody with a 10th grade education, 21 years old, to say what they needed him to say. And they could take the rest of it from there. In that same vein, do you remember after everything happened, Mr. Bowden said that he and Mr. Borum somehow met up later at a park? And Mr. Bowden said that Mr. Borum came up to him and threatened him and said, don't tell anybody about this or I'm going to smoke your clothes. Well, this goes back to Mr. Bowden's credibility, his thought process. He's smart, you've got to watch him. How, if Mr. Borum, by everyone's statements at that time, had no idea anyone was killed? Why would Mr. Borum be saying, don't tell anybody that I killed somebody? Unless Kenny Bowden, who had 13 months to think about what he was going to say, came up with this because he knows he's got to give them an ironclad case. He knows he's got to help them. Help Mr. Borum doesn't do anything for Mr. Bowden. Helping the state gets Mr. Bowden out of prison so he can keep on lying. So maybe he made that part up because it doesn't logically make sense that if he said Mr. Borum didn't know he killed anybody, why would Mr. Borum threaten him to say, don't tell anybody I killed anybody? It doesn't make any sense. And it's because Mr. Bowden had 13 months to come up with his story. And Mr. Bowden didn't come forward with his story until it was convenient for him. If he really knew something, if he really knew what happened at that moment when Justin Carr lost his life, why didn't he do that in October or on September 21st when it happened? You also heard a little bit of testimony from some officers in this case. Detective Luke Amos, a CEU trained personnel, was there during the protest. He testified that he was instructed not to wear a body cam. He got into some other explanation about how maybe it doesn't fit on your vest or on your shoulder or on your helmet. But the real reason that he cleared up for us was that he was instructed not to wear one. Why? Maybe the police don't want you to know what was going on that night. Detective Pack testified about other cameras that were out there that night. But those were live stream cameras, so they weren't recording because we don't want you to know what was going on that night. What were the police really doing that night? They testified they were shooting into the crowd. They testified that they were throwing flashbangs into the crowd. And you remember the picture of Justin Carr's clothes in the trash can when there was clearly one of those canisters, atop of one of those canisters, on top of those clothes? Whoever put that in the trash can might have thought that had something to do with Justin Carr's death. Maybe that's why they put it in the trash can with the clothes. But when asked, did you collect that? Officers testified, no, we took the clothes, we didn't take that. Because that doesn't help their case. CMPD doesn't need any attention on themselves. And so later, when Detective Pack asked about a rounds count, very important detail, Ms. Harris asked him, okay, what is a rounds count? Well, it's how we determine if a weapon was fired after a police officer shoots it. And did you do a rounds count? No. Why not? Well, we determined no officer shot their weapons. Isn't the purpose of a rounds count to determine if the police officer shot their weapons? How long would it have taken? Less than 2 years to go to each of those officers who was there, dressed in that gear, to find out what grenades they threw, what other items they had, and if they fired any bullets that night. But that doesn't fit their case. They don't want you to know what happened there because that's not important to them, because they had their guy. He's over there. And we're going to put him away for life in prison because we can't have this come back on us again. That already happened, and that's ongoing. We can't have it twice in 2 days. So when you think about this case in its totality, the state has presented you a lot of evidence, and I implore you to go back and look at all of that evidence. I implore you to go back and look at some of the state's exhibits that show, for instance, the chaos that went on that night, and how even after it was cleaned up, this is what the scene looked like. And how, even after that scene was cleaned up, there were shell casings, there were bloody clothes left in the trash can, there was blood on the ground, and no officer could tell you how long the scene was contaminated. Maybe this shell casing was dropped by somebody later. As Detective Pack said, it would be irresponsible to test it because maybe it happened later after the fact. And so if that's the case, would it also be irresponsible to accuse my client of firing this shell casing if you didn't test it to see who touched it? Or to pick it up 4 hours later and say it was definitely him, but it's irresponsible to say it could have been anybody else. This is now your responsibility to ask these questions. It's not mine, it's not Judge Hayes, it's not the state's. It's your responsibility to ask, how can both be true? This is one of the most important civic duties we have in this country. That man has the right, had the right at this point, to a fair trial. You all have sat patiently, and we appreciate your attention and your willingness to listen. And now it's on you. This isn't a decision to be reached quickly. This isn't a decision to be reached so you can go home. This isn't a decision to be reached based on sympathy for either side. It's a decision to be based on reason and common sense. It's a decision to be based on the questions you have left over about what the state just chose not to do because it didn't fit their narrative. It's a decision about a man's life. I want to briefly just tell you about what the potential other sentences are in this case. We understand that first-degree murder is life imprisonment, no parole. We beat that over the head. If you find Mr. Borum guilty of either of the either of the first two under second-degree murder, that being malice, meaning hatred, ill will, or spite, or malice defined as a condition of mind, I won't read it all again, but those first two, Mr. Borum faces up to 28 years in prison. Mr. Borum is 23 years old now, faces 28 years in prison. If you find The third option under second-degree murder, Mr. Borum faces 18 years and 9 months in prison. It's a long time. That is enough time to miss an entire lifetime. Enough time to miss out on a family, enough time to miss out on jobs, enough time to miss out on everything. And I understand, and I don't want to make it seem like I am crass. The Carr family has lost a brother, a son, and a father. And that's not to be taken lightly either. That is important because nothing that any of you do or I say is going to change that. And that hurts. And it's okay to feel that pain. But it's not okay to use it in the deliberation over this case. That's got to be based on the facts alone. And the state wants you to now take another man's life, livelihood, family, based on 51%. Based on a medical examiner who told us, yeah, it could have been some kind of pin, or long rod, something like that from some kind of explosive device. And then said, well, no, I don't think they had that stuff out here. But he doesn't know what they had. And neither do we because the rounds count didn't happen. There's a policy in place to do that so you know what happened, what was fired, what was thrown, what exploded. We don't have that because they didn't do it, because they didn't want to. That doesn't help this side. That might help the other side. And so before you decide to send the man away for the rest of his life, think about what was really going on that day. This is chaos. There's smoke. One of the witnesses testified there's fire. There's mace, something stronger than mace, in everyone's eyes, so no one can really see clearly what's going on. But that chaos didn't start until the police showed up in riot gear. Before that, it wasn't chaos. It might have been unrest. It might have been protest. Not until those police showed up and started making physical contact with people did it become wild, did it become chaotic, did it become terrible. Just like the protest wouldn't have happened at all if the night before a man hadn't been killed by CMPD. They're covering their tracks. So the only decision left is my client. That's not the only decision left. Think about Mr. Borum's state of mind. To be guilty of first-degree murder by premeditation, deliberation, and malice, the judge is going to instruct you that you've got to be in a cool state of blood, clearly understanding what you're doing, and intentionally, deliberately doing that thing to cause that result. And now, some people might argue that firing a gun in and of itself is inherently dangerous, and if a bullet comes out, then it's meant to hit somebody, and that's enough, but it's not. And that's why the judge is going to instruct you on second-degree murder. Because in second-degree murder, malice can be presumed just by the firing of the gun, regardless of what the intention was. And I would argue to you, ladies and gentlemen, that depending on what state's witnesses you believe or don't believe, that's the most they've proven. If you believe Kenny Bowden, he was going like this with no aim. If you believe Ryan James, shot had already been fired, but he was just kind of pointing like this and turning and running. If you believe what the police told Mr. Borum, he's shooting in the air to clear the crowd. The only person who said he meant to shoot a police officer was the only guy with a whole bunch of fraud convictions and something to gain by the result of this trial. And so when you make that decision based on that man's testimony, as clever as he is, as smart as he is, as good as he is at what he did, make sure you're positive that he's telling you the truth. Make sure you believe him, because that's the only way the state can prove there was premeditation in this case. When you're thinking about riot, again, think about why the riot started. Think about the fact that this was peaceful before the cops showed up. And so by the state's argument, everybody out there is guilty of felony murder, right? Because if a riot ensues and there's damage to property and there's more than 3 people there, you can be found guilty of felony murder. And so the police and the other protesters and everybody involved, if it was a riot, is guilty of felony murder. Not just my client, everybody. But they're using that as a tactic because they know how bad Kenny Bowden's testimony is for them. They know that whatever he says can't be taken as far as you can throw him. He's a big guy. That's why they need to use this backdoor angle to try to get you to believe that this was first-degree murder, because they've got nothing else to show that there was any intention on Mr. Borum's part. How can there be an intention to do something like shoot a police officer if the police officer aren't even visible to you when you're shooting? If you believe these people's testimony, this was a quick, unaimed shot. No one says that he was getting set and picking out a police officer to shoot at. And so when you read that direction for transferred intent, and it says, if you're aiming at one person to hit another person, take that literally, because the state legislature writes these rules, and our courts write these rules. And if they meant to say firing to a crowd means that it transfers to one person, they would have written that down, but they didn't. What they wrote down was if you're aiming at one person and you hit another person, that person steps into that other person's shoes. That's not what happened here. If you believe Mr. Borum shot, he wasn't aiming at anybody. This was a wild shot based on the state's evidence testimony. Take your time. Look at all of the evidence. Ask questions. Don't take just this corner of the puzzle. Think about everything that was going on. And when you do, at best, the state may have proved second-degree murder. But I would argue to you, ladies and gentlemen, that the state hasn't proven any murder. The state hasn't proved that Mr. Borum, in fact, shot Justin Carr. Because the state hasn't proved, except for 51%, that a bullet even would kill Justin Carr. Not my words, not Ms. Harris's words, the medical examiner's words. 51%. That's civil court. That's money. This is liberty. And he deserves that consideration. Because although Mr. McCallum said the presumption of innocence is over, it's not over until the judge sends you into that deliberation room. And so right now, even still, Mr. Borum is presumed innocent of all these charges until you go back into that room and deliberate. Be careful, think, speak with each other, and ask questions. And when you do, I ask you to return a verdict of not guilty on first-degree murder. In the alternative, if you believe Mr. Borum shot, I ask you to return a verdict of second-degree murder at the less included offense. But I would argue to you, ladies and gentlemen, the state just hasn't proved that Mr. Borum shot Mr. Carr at all, except at 51%. It's just not enough. Thank you.
Thank you, Mr. Simmons. Ladies and gentlemen, if you plan on leaving out the opportunity, once the judge begins instructing the jury, no one is allowed to leave. Please proceed. Jury instructions. Thank you. Ladies and gentlemen, since it's a little after 11 and these instructions are extremely important, we're going to take a break before I come in and read the instructions to you, okay? Yeah, it's our normal time for a break. This is a good time to take a break. Remember, during this break, and I was looking for my reminder thing out here, I misplaced the rules, but you remember what they are. Don't talk about the case amongst yourselves, even at this point, especially at this point. I'm not giving you the instruction amongst yourselves. Don't form or express any opinion about the guilt or innocence of the defendant, nor express to anyone any opinion about a case until just a little while after I finish the instructions. I tell you to begin your deliberations. Don't have any contact with any of the parties, attorneys, or witnesses. Don't watch, read, or listen to any media coverage. As you can tell, every day this honorable court now stands in recess for 15 minutes. 15 minutes. Please be seated while the defendant backs.
Deputy Evans, everything okay? Okay, okay. Do we need to wait?
We're just trying to make sure we're ready to approve it and the possibility of putting a sign up so they can.
Okay. I noticed the Carr family is not here. Is that all right? Have they chosen to go elsewhere?
Yes, sir.
Okay.
That's a brother is here.
That's fine. I just want to make sure if I needed to wait.
Yes, sir. We're fine to proceed.
Okay, we're ready for the jury. Reading to you will be in with your verdict sheet, okay? Members of the jury, all the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law which I'm about to give you to those facts. It is absolutely necessary that you understand and apply the law as I give it to you and not as you think it is or you might like for it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied. The defendant has entered a plea of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove that earn one of the following verdicts: guilty of first-degree murder, guilty of second-degree murder, or not guilty. You may find the defendant guilty of first-degree murder either on the basis of malice, premeditation, and deliberation, or under the first-degree felony murder rule, or both. First-degree murder on the basis of malice, premeditation, and deliberation is the intentional and unlawful killing of a human being with malice and with premeditation. The law will be delivered to the jury. As long as you stay close for any questions, that's all I require. Okay, thank you. Where's the sheriff? I guess you could. Yeah. I'll give it to you.